I'll start today's webinar on crisis scenario planning with an acknowledgement of country. This is a photo of the North Shore suburb of Camaray, where this meeting is taking place. I begin today by acknowledging the traditional custodians of the land on which we meet and pay my respects to the elders past and present. I extend that respect to Aboriginal and Torres Strait Islander people here today. I delivered this presentation from the North Sydney local government area, and I acknowledge the Camaragal people as being the traditional owners of this land and pay respects to elders past and present. So welcome to today's webinar on crisis planning scenario. My name is Caroline Chan, Engagement Manager for LexisNexis Practical Guidance Australia. We also have Roxana Sandarasa, who will moderate the Q&A. This webinar lasts for 60 minutes, including 15 minutes for Q&A, and counts towards one CPD point for most states except for WA, which has different CPD compliance rules, so please check the Legal Practitioner Board's website. We will first look at our supersized crisis scenario, and after taking a deep breath, we will look at what we know of the issues and how to manage a crisis from a legal or risk practitioner's standpoint. We will delve into the crisis deeper by breaking down what we will need to do in the context of each practice area and how the content in practical guidance may help ease the situation. Our presenters today will also include Ellie Bassingwaite, who will take us through the crisis on underpayment and employment. Alison Cripps will talk about the media frenzy item on Cyberattack and data breach and the critical cybersecurity function to organizations. Jennifer Bannon will present the always relevant topic on merger and competition. And finally, Luba Puchensky will help us stay the course on corporate disclosure. We know that we're covering a lot during the next hour, and I like to point out that through previous in-house experiences from our legal writers, some of these are actual scenarios from their experience in organizations, both public and private. We hope that you will enjoy today's webinar, and if you'd like to see other crisis scenarios played out for us to run next year, do let us know by sharing your thoughts in the Q&A. Thank you, and let's begin. So imagine this, you're a corporate lawyer or risk manager for iFoods, an ASX-listed global fast food chain with outlets in Australia. It's 9 a.m. on Tuesday morning, and your inbox is flooded with emails asking, have you seen this? So then I went into the Sydney Times, and it's confronted by the news headline and the article on how we've underpaid a former employee from 2016 to 2018, and at the same time we have received a merger proposal. We barely have time to digest the crisis in front of us when a call and an email from the MD came to our inbox. And that email looks like this. And now we're also facing a group of hackers by the name of Attack Collective, who's demanding $10 million in Bitcoins, or our 7 million customers' personal data will be exposed to the public. Later that morning, you notice that the share price for iFoods has a big drop, and later today we have an urgent meeting with the executive team. So what do we do next? Based on the scenario, we can start by identifying the areas where a breach may have occurred. How will we address each one and localize the issues? How will we manage communication internally, externally, and to the press? Are there preventative measures that we can take to future-proof similar crises from happening? A line of our speakers will each address the crisis situation relevant to a practice area, and we will introduce you to the relevant content from LexisNexis Practical Guidance platform. Switching now to practical guidance. There are 24 practice area modules in Australia. So let's start by going into the module specifically designed for in-house practitioners called In-House Advisor. Each module has a topic tree made up of content to the practice area for ease of browsing through point and click. As we can see, the module has a range of topics relating to management issues, operational issues, risk management, contracts, outsourcing and procurement, as well as training and in-house insights. We will start by choosing risk management and select the subtopic on crisis management. As the scenario is quite urgent, the relevant documents on how to manage a crisis, as well as the crisis management action list, are going to be relevant. Going back to how to manage a crisis, the three headings that should take priority are: is there a risk of additional immediate and irreparable harm? Who will deal with the crisis? And if we refer back to the crisis management action list, this coincides with the first step of the precedent management checklist, which advises that the first step is to assemble the crisis management team. The third step determine how the crisis management team will communicate. For this step, we could refer back to the guidance note, which includes details such as how will the crisis team communicate? Does privilege apply? What information do we have and what is missing? External reporting, as well as dealing with media inquiries. We could also refer to a separate guidance note called Managing Communications in a Crisis. This enables us to handle the crisis communications to various stakeholders, including the media, social media, internally with your staff, as well as external parties. Handling communications during the cyberattack will be covered in detail when Alison talks about cyberattack in the cybersecurity slides. So apart from managing a crisis, this module offers lots of resources to help us plan ahead to proactively manage the risks. By switching to the risk management topic, we can also consult resources such as identifying risk, to help us plan ahead. Under tools and resources is where we can also find a bunch of training materials. And these are white label training materials aimed at both lawyers and non-legal staff on data breach, modern slavery, underpayments, and competition law compliance. Each presentation can be branded as your own, has speaker notes, case studies, as well as a list of key resources. Thank you, and I'd like to turn to our next presenter, Ellie, to cover underpayment crisis. Thanks, Ellie.
Thank you, Carolyn. So turning to the issue of the historical underpayment, the first step is to consider whether iFoods has complied with its obligations and duties, or whether there has been non-compliance that potentially exposes the company to an underpayment claim. Now, the first part of this process must be checking what records iFoods has kept. Accurate record keeping is one of the employer's obligations, so it's something that they can be potentially fined for if they've failed to meet it, but it's also the only way to assess whether the ex-employee was properly paid. The guidance relating to record keeping obligations sets out the records that employers are required to keep, along with a description of the details required for each record. And you'll note that there's a specific section about the contents of payslips. And it also sets out the penalties for non-compliance with these obligations. There's also important guidance regarding how the onus of proof is reversed in claims for unpaid wages where the employer has failed to keep the appropriate records. So right away, we know that if iFoods haven't kept the proper records for this particular employee, there are going to be some significant issues for them, both in terms of the potential penalties and also in terms of how they defend the claim. But who is them when we speak about them? There's obviously a risk for the company, iFoods. However, certain individuals may also be liable as accessories to the contraventions. If we go to the guidance note about liability for underpayments, we can see that accessorial liability arises in circumstances where an individual has direct knowledge or involvement in the contraventions. So, for example, the manager who might have been involved in rostering on this particular employee, payroll officers, HR staff, even in-house legal or general counsel, if they were involved in setting up or implementing a system where employees were paid improperly at a flat rate, regardless of the hours that they worked. Those individuals could also be personally liable for the contraventions. The guidance note also includes details of the maximum penalties associated with remuneration-related contraventions. Now, once we've got an idea of the maximum penalties, we can use the employee underpayments expert to get a clearer picture of the likely penalties. This tool allows users to filter through previous court decisions relating to underpayment contraventions primarily based on the facts of their matter and locate relevant cases quickly and accurately. So if, for example, we were wanting to advise the general manager on their exposure to penalties, we could filter according to the position of the person and see at a glance what penalties had been imposed in similar circumstances. So now we have an understanding of the potential contraventions, the likely exposure of both the company and certain individuals. It's time to consider a strategy for dealing with the alleged underpayment. For example, if it's a systemic issue affecting multiple past and present employees, we need to consider whether iFoods takes a proactive approach and notifies the Fair Work Ombudsman, the regulator, with a view to entering into an enforceable undertaking. There's guidance about dealing with the regulator on issues relating to enforcement and compliance that can be used to inform this strategy. And of course, you can use the employee underpayments expert to assess the terms of previous enforceable undertakings to, again, provide more tailored advice to this fact-specific scenario. Now, once these immediate concerns are addressed, it's time to look to the future. How do we address these issues, the issues that led to this scenario arising? This might include reviewing the employment contract to ensure that there are effective annualised salary clauses or effective set-off clauses in the contract going forward. So if the employer does wish to pay award-covered employees at a flat rate, they're doing so in a way that's not going to expose them to underpayments. If that's a course the employer wants to take, then that's something that our precedent optional clause could be used to achieve simply by inserting this clause into the template contract going forward. It may also be the case that the employer wants to update its training material to assist the relevant managers in identifying potential scenarios that could give rise to an underpayment in the future. And Carolyn highlighted the white label training material that we've got available earlier regarding underpayments and wage theft. Thank you, and I'll turn to the next presenter, Alison Cripps, to cover cyber attacks and data breaches. Thanks, Alison.
Thank you, Ellie. It's possible for many of us present today that the cyber crisis that iFoods is facing in our imagined scenario would have felt far-fetched only 6 to 12 months ago, but not anymore. I think we're all hyper aware now, thanks to recent cyber events, that a cyber crisis is a very real possibility for many to most organisations. It's not lost on any of us that the current global political climate, as well as our increased tendency to work from home since the pandemic, has heightened the risk environment and placed increased demands on legal departments and risk managers to pay attention to cybersecurity at levels previously unheard of. It's no longer considered to be a job for the tech people in the back of the room. Cybersecurity is front and centre of the business. Whilst we can increase organisational resilience and reduce risks, and we can use the content in the cyber module to assist us to do this, none of us are immune to being at the wrong end of a cyber event. Fortunately, there are great resources available in the cyber module to help us in this circumstance. So let's go there. We are now staring into a cyber threat situation, having just received a ransom from a known criminal group demanding payment of 10 million in Bitcoin. If we don't pay, the known criminal group threatened to release the personal data of 7 million customers onto the dark web. Your technical team has checked. The email is legitimate and the data has been breached. Fortunately, no data has yet been released, so you breathe a very temporary sigh of relief. We may have already familiarised ourselves with the cybersecurity, data protection and privacy module to plan for an event like this and to develop a robust cybersecurity strategy. This would have included preparing an incident response plan, identifying key stakeholders, using the guidance in the module to ensure best practice with data storage, complying with Australian privacy laws, and since some of our imagined iFood customers are potentially international university students or holiday makers who ordinarily reside in Europe or in China, we have used the resources to ensure compliance with the EU's GDPR and China's personal information protection laws. So with our already robust systems in place, it's possible we have a relevant crisis team determined and on standby, and we can call upon them to respond to this crisis. The snapshot of the cyber content, thank you, Caroline, provides you with an outline of what's in the cyber module, and you can see there's a lot of content that would assist you to implement best practice in advance of a cyber event. So in our scenario, we imagined that some of our customers might be university students or international holiday makers. And so I thought I'd quickly show you one of our questionnaires from the module, which addresses the question of whether China's personal information protection law would apply to organisations that manage data. Given it's possible some of our university students could be international. Our hypothetical legal counsel or risk advisor might have used this checklist to deal with the question of whether the personal information protection law of China would apply to govern data storage. But before we digress too far into interesting questions of extraterritorial application of Chinese law, let's head back to our crisis. As legal professionals and risk professionals faced with a cyber crisis, we are going to play a really important role in determining our communications response to this event. Caroline has taken you through the content from our in-house module on communications response to a general crisis. The cyber module has detailed guidance specifically on a communications response to a cyber crisis, including some great training materials that can assist you to deliver a pre-crisis training session to your staff. But at this point in the crisis, communications response becomes critical. We may carefully familiarise ourselves with the guidance notes and communication strategies for cyber events, ensuring we meet best practice when communicating with the media, internal staff, and external stakeholders. We'll use these materials to assist us with preparing our communications response, including to guide us on who to notify, when to notify, who to notify first, and what to say. This process will involve considering our notification obligations to regulators, affected individuals, suppliers, contractors, subcontractors, to our insurers and to any shareholders. And of course, we are going to want to achieve best practice when communicating with staff, the media, and any other stakeholders. We can use the checklist shown here on the cyber communications response to assist us in responding appropriately. As part of our communications response, we are going to have to carefully consider whether we have obligations to notify the Commissioner and impacted individuals under the notifiable data breach scheme. We may previously have briefed the board and senior executive staff using white label training materials from the cyber module on data breaches. So we are familiar with notification requirements for eligible data breaches. We suspect that this event is going to constitute an eligible data breach because of the potential for 7 million customers' personal data to be exposed. But we can use the checklists available to us to identify when the data breach is notifiable and whether any exceptions apply. If we determine that it's notifiable, we can use the mandatory data breach notification guidance and the workflow checklist, including the checklist shown on the screen here, to help you step through the contents of notification and to guide you through the notification process. And of course, whilst we are taking care of the communications crisis and notification to relevant authorities, let's not forget that our hackers have asked for a ransom, and we may be called upon to give advice to iFoods about paying the ransom. We can review guidance in the cyber module on ransomware to ensure that we have considered the system considerations and the legal and regulatory considerations of paying a ransom, and to ensure we are asking the right questions to our board, our executive, our crisis team, and our insurers. As with most ransomware demands, this one is in crypto. Fortunately, there are some great guidance notes available in the cyber module on crypto so that we can brush up or deep dive into blockchain, and we can understand the language of our hackers and our cyber insurers if we have them, and even use the guidance to help us set up a trading account if we need to pay a ransom. And when it's all over, we can use the numerous resources available in the module relating to data storage, data privacy, and cybersecurity to review our response to the crisis and improve our own cybersecurity strategy and organisational resilience. I'll now turn to our next presenter, Jennifer Bannon, to cover the merger and competition crisis. Thanks, Jennifer.
Thanks, Alison. Well, it's never a dull day for an in-house lawyer or risk manager. Just our luck. Not only are we dealing with a cyber threat, employment underpayments and impending legal proceedings, but of course, we've just received a merger proposal from one of our emerging competitors, Dinalog. So the task that you would need to undertake to advise on a merger proposal like this from a competition law perspective would first of all involve reviewing that merger proposal and making sure you understand the commercial structure. Next, you'll need to draft competition law prospects advice on whether this merger can proceed from a competition point of view. You'll likely need to advise executives and the board of the proposal, identifying any competition law risks. And as part of this task, you'll want to have reviewed previous ACCC merger decisions to ensure that your advice is comprehensive and takes into account how the ACCC has defined food and related markets in the past. Of course, you'll want to ensure that iFoods avoids a breach of competition law during the course of any discussions or interactions it might have with Dinalog at this stage. And finally, you'll want to identify the processes and relevant timeframes for notification to the ACCC if that's deemed necessary. The good news is that the practical guidance competition module can help you answer all of these questions. And if we look now at the competition module, you'll see that it's structured by topic with the breadth and depth you would expect across the range of competition law issues and prohibitions from the regulatory framework to anti-competitive conduct and misuse of market power, as well as competition law litigation, compliance and penalties and remedies. But turning to the current scenario, this merger proposal between your company, iFoods, and the emerging competitor Dinalog, we would perhaps want to refresh our memory on the merger provisions, and we have a separate topic, as you can see, for mergers on the detailed guidance considering mergers and acquisitions that substantially lessen competition, which are prohibited under Section 50 of the CCA. We also cover the factors the ACCC will need to consider, as well as identifying any risks like gun jumping and merger enforcement issues. You can see in this guidance note that we cover and we hyperlink to relevant legislative sections, as well as linking to relevant cases. And we cover all the essential elements of deciding whether a merger will substantially lessen competition, such as what is the meaning of that term, assessing the counterfactual, looking at the terms of substantial and competition and market, as well as covering recent proposed reforms for merger review. And we guide you to relevant cases and other tools and checklists within the module that can provide you with more detailed information should you wish to dive deeper, as well as linking out to external resources. So in this case, we would link to any relevant ACCC speeches or guidelines. In terms of the merger factors that you might wish to consider when you're looking at a merger proposal, we cover that in both guidance and checklists. And we'll turn to a checklist now just to show you what one of those looks like. As you can see here, this checklist is very practical. It would be very useful in the context of an iFoods Dinalog proposal because it looks at each factor, it hyperlinks to the section and looks at each of those factors step by step. An in-house lawyer could, for example, copy this table into your merger prospects advice and even add another column for how you're going to obtain this information and address this issue for your current situation. The next step in this merger proposal situation would be to research similar merger cases. And you can do this by using one of Practical Guidance Competition's most popular tools. It's our ACCC Merger Case Tracker. And this tool tracks the ACCC's completed public informal merger reviews from 2002 to now, summarised using a very simple interface. And if we scroll down, you'll see that we have just 4 columns, so it's very easy to navigate. And that first column looks at the merger parties, which is hyperlinked to the ACCC's merger case register. And if we go back, you'll see that the second column addresses the relevant sector or industry, which includes the ACCC's nominated industry, which we have overlaid with a broader category of sectors to help with searchability. You'll see then we summarise each merger in one sentence, looking at the issues that may have been involved and relevant markets. And finally, we cover the decision itself. For example, whether the merger was opposed, not opposed, subject to undertakings, whether it went to market inquiries, statement of issues, or a competition assessment. So this useful tool significantly cuts down research time and it circumvents having to navigate the ACCC's merger register, which can be a bit clunky. So for the proposed iFoods Dinalog merger scenario, we would naturally want to review all mergers that the parties themselves have been involved in the past. Given they're fictitious, we won't search for results for them, but you might instead search for all your competitors. So you might simply just use the Control F function to search for Coles or Woolworths or Menulog. And by searching for Coles there, Caroline has generated results covering Coles in every merger scenario from 2022 to 2002 when the merger register became available. You know, you may also wish to search for something like the industry or the sector that you're involved in. So for example, you could search for food or you could search for takeaway. Equally, you could search by outcome. If you wanted to search for all mergers that have involved undertakings, you could search for that term. And of course, that will generate all mergers that have been subject to undertakings that the ACCC has reviewed. So once you've completed your research, you'll finalise your draft advice to the board, identifying likely procedures and timeframes for notification. And we have both guidance and checklists covering the relevant processes, including informal merger notification and formal authorisation. And of course, during the structuring and negotiation stage with Dinolog, it will be essential that the business understands what information can and can't be shared. So we've got a great checklist here on how to avoid, for example, gun jumping, which might arise when you're dealing with a potential competitor in a merger proposal. And that gives you some tips on how to avoid engaging in cartel conduct and those sort of appropriate boundaries for dealings with competitors. And finally, as Caroline mentioned earlier, we have training materials, white label training materials on competition law. And in December, we're publishing new PowerPoint training materials on competition law issues in M&A transactions. So that covers it now for competition law. And I'll pass to my colleague, Luba Puchansky, our legal writer for Practical Guidance Corporations, who will now talk you through the corporate disclosure issues facing iFoods.
Thanks, Jen. So let's discuss how an in-house corporate team might assist the board in dealing with this complex crisis. First of all, ideally, iFoods would have previously established a dedicated audit and risk committee that would take the lead in managing this situation. Our guidance on components of a corporate governance framework sets out the role of board committees, and we also have precedents for an audit and risk committee charter and a resolution of directors to appoint a committee. And we'd also expect the company to have established business continuity plans that would now be put into effect, as detailed in our guidance on reliance, delegation, indemnities, and decision-making by directors. Compliance is obviously key in dealing with this crisis scenario. And from corporations law perspective, the major aspects are ensuring that the company meets continuous disclosure obligations and that directors adhere to their directors' duties. We have detailed guidance on the ASX listing rules and on continuous disclosure requirements under both the listing rules and the Corporations Act, including what information is material and when and how disclosures to the market must occur. You'll be able to see that the guidance also contains practical tips and hyperlinks to further information on Lexis Advance and to the full text of the listing rules themselves and associated ASX and ASIC resources. This is obviously an important and topical area for legal and risk professionals to keep up to date with temporary changes that came into effect in response to the effects and uncertainties of COVID, followed by permanent reforms to Chapter 6CA of the Corporations Act in August 2021 to introduce a new fault requirement of knowledge, recklessness or negligence for continuous disclosure breaches. There've also been a significant amount of high-profile litigation related to alleged failures of market disclosure obligations in recent years, both shareholder class actions and ASIC enforcement and regulatory action. And here, given the effects on our share price that have already occurred, you obviously would conclude that market disclosures need to be made regarding this potential merger, the cybersecurity breach, and also the employee underpayment concerns if those prove to be systemic. Regarding directors' duties, we have a quick guide to directors' duties that provides an overview of the duties owed by directors and how to avoid liability for breach. Also a checklist of practical tips for complying with directors' duties, which is a very useful resource for directors and their legal advisors to refer to any red flags to keep in mind in assessing issues and making decisions, particularly in a fraught and high pressure crisis situation. We then have more detailed guidance on directors' statutory and common law duties and the consequences of breach, if you need to go into further detail. Directors will likely wish to access various company records and information in coming to grips with this crisis. And for that, you could refer to our guidance on access to information and confidentiality, which details the circumstances in which directors are entitled to demand company information and restrictions on its access and use. In-house counsel and risk professionals would have to act quite quickly to brief the board and hold a board meeting to address this situation. And to assist, we have a meetings topic which comprehensively covers that process. You would need to put together board packs to brief the directors on options to deal with the scenario. So we have precedents for board papers for decision, for discussion, and for noting, each with helpful drafting notes. The directors' meetings and resolution subtopic contains guidance on the process for calling and holding a board meeting and requirements for minutes and resolutions. And we also have a suite of precedents that are linked and accessible both from within the guidance itself and also from a separate precedents tab, which includes commonly used board resolutions, a notice of directors meeting and minutes of a directors meeting. Also linked in the guidance and available in a separate checklists tab are some helpful checklists, including a checklist of key considerations when circulating a written resolution of directors that would guide you quickly to the view that the complex and contentious issues that would arise in a crisis are not appropriate for a circulating resolution. So we have then the checklist for calling a meeting of the board of directors, which takes you through the whole process from pre-meeting considerations to convening and conducting the meeting. And this in turn links back to the guidance and precedents that I mentioned. So you can see everything's intended to be quite intuitive, easy to navigate as part of your natural workflow with all the sources interlinked so that you're directed to all the relevant content at each stage. Given the urgency of this situation and the increasing shift to virtual meetings accelerated by COVID, this directors meeting is likely to be fully or partly virtual, especially if called urgently. And so we have a subtopic specifically on virtual meetings and related issues, which covers practical matters relating to virtual meetings. Again, an area in which there's been a lot of recent change with temporary relief measures enacted in response to COVID, followed by permanent reforms. So it's important for legal practitioners and risk managers to be up to date on the current state of play. And our guidance is clear and cohesive in providing that. We mentioned that a merger proposal had been made by Dinalog. And as part of documenting that, you may want to refer to our checklist of tips for drafting and finalizing a transaction document. This is a very practical resource. It's drawn from our own practice experience of the types of things to check, errors to watch for, especially when you're drafting documents under pressure and to a tight deadline. So it's quite useful to be able to tick off that you've covered these basic things, that it's easy to slip in the heat of the moment. Finally, it's crucial to make sure the merger documentation, settlement documentation for the underpayment dispute, and any other documents relating to the crisis is validly executed and therefore fully enforceable. We all know it can be very tempting for busy lawyers working to a tight deadline to cut and paste signing clauses from old documents. This can be very risky. The law around execution of documents is yet another area that's undergone quite a seismic shift due to the effects of COVID, with electronic signing now becoming very ubiquitous and permanent reforms to the Corporations Act recently enacted to allow for this. So I'd encourage you to refer to our topic on electronic signing, which includes guidance on electronic signing by companies and witnessing documents remotely. And you could also use our very popular signing tool, which is available in the modules, tools and resources tab, and provides a user-friendly step-by-step process where you can click through a series of prompts to create correct execution blocks for agreements, multi-party deeds and deeds poll for a range of parties, including companies, but also individuals, partnerships, trusts and schemes, and including for complex documents that may have multiple parties. It also contains helpful tooltips to ensure that you select the correct options and to provide further information on signing formalities. The tool's been recently fully revised and updated to take account of the legislative changes that I mentioned, and it now has 235 new and updated signing clauses. Okay, and I will now hand back to Caroline.
Thanks, Luba. I hope you've enjoyed the mega-sized crisis scenario and the presentation on how to deal with the mini crisis situations by using the practical guidance resources available. As you can see, we have demonstrated in a small chunk of the extensive guidance notes, precedents, checklists, and tools, including underpayment penalty, as well as the case merger tracker. In addition, having access to the training materials for both lawyers and non-legal staff will put you in control as you are supported by having compliance and risk mitigation measures. So I'd like to thank all our expert authors and presenters today. And they include Ellie, Alison, Jennifer, and Luba. With that, I would now like to invite you to join us on the Q&A forum. Turning over to you, Roxana. Thank you.
Thanks, Caroline. I've got a question for Luba. And so they've asked about practical guidance and in terms of keeping up with recent legal updates, does practical guidance provide any resources for that? So Luba, over to you.
Thanks, Roxana. Great question. So we monitor developments relevant to each practice area. In this case, it would be corporations, and prepare latest legal updates that briefly summarize these. Usually there are at least 3 of them a week. They're available in the separate latest legal updates tab on each module homepage. And these may be reports of important court decisions handed down, regulatory or enforcement proceedings that have been undertaken by ASIC or other regulators, new legislation or legislative instruments enacted or coming into effect, or public consultations announced by, again, Treasury or ASIC. The latest legal updates also usually provide key takeaways, distilling the important points or implications of these for practitioners to keep in mind. And they also link back to source materials such as full text judgments or bills, and also to relevant guidance and other resources within our own practical guidance modules. We then have a fortnightly roundup, which is an email newsletter for each module that gathers together the headlines of all the most important latest legal updates for the fortnight. And it contains key calendar dates for practitioners to be aware of, whether there are dates for legislative and regulatory changes to come into effect, or financial reporting deadlines, or deadlines for submissions or consultation responses, other useful dates for your diary. And then the roundups also highlight new and enhanced content within practical guidance and upcoming webinars such as this one. So anybody can sign up for these, whether or not you are actually a practical guidance subscriber, and I would encourage everybody to do so.
Thanks, Luba. The next question is for Alison. Do you have any views and observations about the recent Optus and Medibank breaches? And what sort of factors would you consider when being faced with a ransom demand?
Okay, thanks, Roxana. Look, I'm not in a position to comment on the specifics of the Medibank and Optus breaches, but there's been a lot of media coverage about whether Australian privacy laws are sufficient and whether solutions to cyber events could be found in the likes of implementing legislation that's similar to GDPR, which is Europe's general data protection regime, and I can make some observations around that. Legislation alone is not likely to protect us from cyber attacks. Regardless of the strength of any legislative regime, in a digital economy, we will remain at risk of cyber attack. And part of the reason for this is the threat environment is often unique to each organisation, and so the solutions, of course, are unique also. Legislation, however, can make cyber attacks less likely by imposing obligations upon organisations which encourage them to make cybersecurity a priority and to implement measures that effectively mitigate security risks and to protect data. For any legislation to be effective in mitigating cyber risks, I think there are 3 things that need to happen. Firstly, the legislation must impose obligations that, when implemented, will mitigate security risks, and legislation must then adapt to the changing threat environment as new mechanisms for cybercrime evolve, so should the legislation. Secondly, regulators must effectively enforce that legislation, and this includes applying penalties for breaches even when there's no cyber event. And thirdly, the consequences of breaching the legislation must be significant in order to incentivise organisations to comply with that legislation. Often these consequences are financial, but directors can also be held personally liable for cyber events under their AFSL licensing obligations, or their licenses to operate a business can be tied to compliance. Our current legislative regime imposes very similar obligations on data security as what is imposed under the GDPR. There's not a lot of difference. The proposed amendments to the SOCI Act will also see increased obligations relating to data management and that are imposed on critical infrastructure organisations such as water, electricity, sewerage, telecommunications assets. Currently, the penalty for non-compliance of the data security provisions of the Privacy Act are around 2.1 million. And the proposed amendments to the Privacy Act will increase these penalties to around 10 million per occurrence. And this larger penalty regime is closer aligned to the penalties that are in place in the UK and Europe through GDPR and in China through the PIPL. Larger penalties are likely to encourage more organisations to adopt safer data management practices. But are they enough? We can see through the many examples of cyber breaches that have occurred in the UK and in Europe, where they already have the larger penalties under GDPR, but we still see cyber events, that large penalties alone are not the complete answer to preventing cyber breaches, even in regimes where legislation is effectively enforced by the regulators. Risks will still remain. Effective strategy requires legislative reform to be coupled with investment in cybersecurity resourcing, including dedicated cybersecurity agencies with in-house technical skills, defence strategies, robust threat intelligence, and government investment generally in cybersecurity and cybersecurity skills development. And Roxana, I've already forgotten the second part of the question.
Hi, Elsa. So that was another question, but it was just the factors that should be considered when faced with a ransom demand.
Well, in the interest of time, I implore you to have a look at our guidance in the cyber security module. But I do preface it with a comment that it is generally advised not to pay the ransom. That is generally the official stance, is not to pay the ransom, but factors that you may consider, interestingly, will include whether your threat actor is a reliable, good criminal, if there is such a thing, and what their history has been in relation to previous ransom payments, whether they have a history of allowing the data to be returned. And so remarkably, the concept of a good criminal in the cyber world does exist.
Thanks, Alison. We've got another question in regards to competition. So, Jen, how does the recent Treasury Laws Amendment Act affect penalties?
Thanks, Roxana. So last week, or I think it was last week, maybe it's the 10th of November, so it might be nearly 2 weeks ago, the penalties increased for both corporations and individuals for certain breaches of the Competition and Consumer Act from both a competition perspective and a consumer perspective. So that applies to both the pecuniary penalty that applied to corporations, which was increased fivefold. It went from 1 million for a corporation to a maximum of 5 million. And for individuals, those penalties were increased from 500,000 to 2.5 million, along with a range of other changes to the way that penalties are structured. So these laws have, as I mentioned, now been enacted. They took effect on the 10th of November. And it was really sort of prompted by the change in government, the Labor government's better competition policy that it announced earlier in the year. And then there was consultation around those penalties, but they've been really sort of discussed for some time. So yeah, those have now been implemented. So now more than ever, compliance on both competition and consumer law is essential for both the corporation and individuals who can be personally liable for things like cartel conduct.
Thanks, Jen. So Ellie, just the last question in regards to what may happen if an employer fails to comply with a compliance notice repeatedly.
Thanks, Roxana. It's a good question. It's a timely question. The short answer is they may be prosecuted for that, because failing to comply with a compliance notice without a reasonable excuse is an offence for which civil penalties can be imposed. The longer answer is that they're quite likely to be prosecuted for that, because what we're seeing is a shift in the strategy adopted by the Fair Work Ombudsman, where instead of pursuing these large, complex underpayment cases on behalf of single or a few number of employees, they have somewhat shifted their strategy recently to issuing compliance notices to employers that require them to rectify the alleged underpayment, and then prosecuting employers who fail to rectify those underpayments. Or fail to comply with those compliance notices. So what we have been seeing as we monitor these developments through the employee underpayment expert is that the number of cases where there's a single contravention that's been alleged has just been increasing steadily. So any employer that fails repeatedly to comply with a compliance notice issued by the Fair Work Ombudsman, where there is not a reasonable excuse for doing so, is really poking the bear. They're really playing with fire there.
Thanks, Ellie. Is there any questions they'd like addressed in this session? If not, that's all good. Thank you everyone for attending this session, and I thank our presenters as well. We hope this has been a valuable learning experience.